Kern Government Television. Welcome to this week's Kern County Board of Supervisors meeting. Originating from the County Administrative Center, located at 1115 Truxton Avenue in Bakersfield, California. Grounded in ideas, energy, and innovation, Kern County's vision is to be a driving force for the world's fifth largest economy. And our mission is to exceed expectations of the communities we serve, changing the way they feel about government, those who manage it, and the services it provides. Today's Kern County Board of Supervisors meeting will convene momentarily.
Board to reconvene. Madam Clerk, please call the roll.
Supervisor Peters?
Here.
Supervisor Scribner?
Here.
Supervisor Maggard?
Here.
Supervisor Couch?
Here.
Supervisor Perez?
Here.
Thank you, and welcome to the Tuesday, October 11th, 2 p.m. meeting of the Kern County Board of Supervisors. We're going to start with a report from County Counsel Margot Raison on actions taken in closed session.
Good afternoon, Mr. Chairman, members of the board. This morning you met on item number 62, and there is no reportable action.
Thank you very much. Okay, now we'll move on to our consent agenda items. All items listed with a CA or a C above the item number are considered to be routine and non-controversial by county staff. The CA represents the consent agenda for the Board of Supervisors. The C represents the consent agenda for the Kern Sanitation Authority and or the Ford City Taft Heights Sanitation District and or IHSS Public Authority. Consent items will be considered first and may be approved by one motion. If a member of the audience wishes to comment or ask questions regarding an item or items on the consent agenda, they may do so prior to a vote being taken on the consent agenda. A member of the board may remove any item from the consent agenda, and it will be considered in listed sequence with an opportunity for any member of the public to address the board concerning the item before action is taken. And I know we do have agendas on the back tables by the doors for anybody who would like to follow along. And so the consent items begin on page 3, and we have items 5 and 6 on consent. And on page 4, we have items 7 through 10 are on consent. However, item 10 has been withdrawn and will not be considered. And page 5, all items 11 through 19 are on consent. On page 6, all items 20 through 26 are on consent. On page 7, we have item 27 on consent, and then skipping down to item 30 through 34, those are all on consent. And finally, on page 8, we have items 35 through 41 that are on consent. And so now I'll ask if there's any members of the audience that would like to make any comment on those consent agenda items that I just read. Okay, I don't see anyone that's wanting to make comment on those items, and so therefore I'll return to the board and ask if there's any questions or comments, and otherwise I'll entertain a motion to approve the consent agenda.
Second.
Okay, you have a motion and a second. Please cast your votes.
The motion is approved. All ayes.
Thank you. And that brings us to back to page 2 and item number 1. This is public presentations. This portion of the meeting is reserved for persons to address the board on any matter not on this agenda, but under the jurisdiction of the board. Board members may respond briefly to statements made or questions posed. They may ask a question for clarification, make a referral to staff for factual information, or request staff to report back to the board at a later meeting. Also, the board may take action to direct staff to place a matter of business on a future agenda. So now I'll ask if there's any members of our audience that would like to make a public presentation. Speakers are limited to 2 minutes. Please state and spell your name before making your presentation. Good afternoon.
Excuse me, thank you. Before the 2 minutes, I haven't come to many county meetings. Do you usually do the pledge in the morning and not in the afternoon?
Yeah, we do the pledge, and we have a moment of prayer, silence, or meditation also in the morning.
Okay, thank you. My name is Phil Corr, C-O-R-R. I live in McFarland. I am also the group leader of the Friends of the McFarland Public Library. I'm going to start off positive, then give you some information as I have time and would certainly enjoy interaction with anyone here today. I would like to encourage the supervisors to continue what they so magnificently began, which is funding the library for 5 days a week. They have had foot traffic pretty regularly all 5 days, averaging of approximately 200. It cannot be done virtually. It cannot be done remotely. But anyway, I would encourage you to continue that, and I do hope that the city council and the manager, who is also still the police chief, will take the county administrative office's recommendations of establishing a temporary mobile unit on the vacant lot right across the street that they bought with bond money a few years ago, and to follow the suggestion of seeking low-interest loans as well as grants. One time, a while back, when there was dialogue allowed, I was told it would cost $17 million. Recently, a new police department. I spoke with a reliable source. I don't have permission to reveal the name, but I was told they reached the 17 million mark. The only contact that was done was in 2018, reportedly, where they called one organization and told them it would cost about $10 million. Well, inflation didn't really start until the last year, and 10,000 is a good number, actually. I don't know if that's exactly what it is, but I really don't think we've had inflation of 70% since then. Thank you.
Thank you, Mr. Core.
No questions, interactions?
Yep.
Thank you.
Thank you.
Welcome this veteran I had the privilege of chatting with beforehand.
Thank you, sir.
Good afternoon.
Good afternoon. Could we have this on your projector? It's just one. Disregard the second one. Again, good afternoon. My name is Ralph Robles. I am a veteran. I am here today to voice my disappointment in this board. At your last meeting, I notified you that there was a serious fire hazard in our neighborhood. Your inaction since then is stunning. No one has even been out to check the house at 2717 La Crescenta, much less reduce the danger. It appears that you are too busy salivating over your choo-choo to nowhere. That project has wasted billions of dollars, and yet not 1 mile of track has been laid. There's not even a train to run on it. You have disrupted communities, farms, and local economies on a system that you were warned was not feasible, as it was not able to scale the mountains between Bakersfield and Los Angeles. Maybe the whole point of the exercise is to see how many billions can be spent on contractors and consultants. I have also warned you that your voting system is designed for election cheating, but again, you have turned a deaf ear. It is possible that that system is suitable for maintaining status quo. Perhaps you are just too enraptured with your freeway that runs through a flood area, goes nowhere, and endangers the few wild species that are left in our area that once made Bakersfield a wonderful place to raise our children. You have also ignored my warning that your ballot drop boxes have no surveillance cameras. You seem blind to the possibility of ballot stuffing. Again, I cannot urge you strongly enough to install cameras on those drop boxes. And I cannot urge you strongly enough to run a forensic audit on your last election and the upcoming one. I will be highly surprised if there is not a tidal wave of cheating in this coming election. Thank you.
Thank you, Mr. Robles. As far as the address, 2717 La Crescenta, is that right? Is that correct? Is that your district, Phil? Okay. Excuse me, Supervisor Peters?
Thank you. Mr. Robles, I just wanted to let you know that when you brought that property up at our last meeting, that was the first my office had heard about it, but we've since spoken with our code compliance department. They have gone out and looked at it, and if I'm not mistaken, I don't know if we can get comment on that right now, but I believe that a 14-day notice was sent to the property owner, which is the legal process we have to do to get that cleaned up. So that was...
So when can I expect to see some remediation in that area to reduce the fire hazard?
Mr. Lux, would you be able to just share a little bit about what that process is? Thank you.
Come on up to the mic, Mr. Lux.
Sorry, Super.
We issued the 14-day notice. I reported it while you were talking last meeting we had. So the inspector went out there, reviewed it, tagged it. We have now given them 14 days, and then they'll have 30 basically to appeal it, and then they have 30 days to remediate it once we go in for abatement.
What about mosquito abatement and rat infestation?
That is it still follows the same kind of a process because I can't legally go onto their property.
Understand?
You know, I can't just go on there and abate that. I have to go through our legal process so I can do that.
Well, I appreciate that, sir.
Okay? And I can
you.
give you my card if you would like for me to
Yes,
follow
please.
up with you. Okay? Let me go get it. It's over here.
I'll step away from the mic.
Thank you, Mr. Lux and Mr. Robles. I agree with you. The high-speed rail is a joke, and I definitely don't support that. So, thank you for your indulgence, Chairman.
Of course, Supervisor Peters, and thanks for mentioning high-speed rail. I wanted to assure you that that's not a project that the County of Kern is conducting. That's a state project by the High-Speed Rail Authority. And this body actually has voted at least on 2 occasions to oppose that project. Once we opposed the business plan, I want to guess that was somewhere in 2011 or so. And then once again, we also voted to oppose it. And so, and we were in litigation with the High-Speed Rail Authority for a period of time. And so that's one that this board has taken an adverse position on, just to clear the record up on that. We appreciate it. Thank you.
Yes, sir, thank you. May I also remind you, although we are in a drought period now, you have a dam upstream that is in such bad shape that when the rains do come, you are at hazard to flood that freeway, that parkway freeway, and put people at danger when it happens.
Thank you. Thank you. Any other comments, please, from members of the public? Okay, seeing none, then I'm going to move on to board member announcements or reports. Okay. Nothing, then we'll move on to item number 3. This is our first item under the Planning and Natural Resources Department. This is a request of Matcon Corporation, Inc. to appeal the decision of the Planning Commission to deny vested mining rights status for the Old Dutch Cleanser Mine on a 280-acre site located approximately 2.5 miles east of the intersection of State Route 14 and Red Rock Inyo Kern Road, and this is in District 1. And so I'm going to turn to Lorelei Oviatt, our Director of Planning and Natural Resources, to start the discussion on this item. Good afternoon, Ms. Oviatt.
Good afternoon. Thank you, Chairman Scrivener, members of the board. I'm here today with Craig Murphy, Assistant Director. So this matter, as you said, is an appeal of the decision of the Planning Commission on June 9th, 2022, not to grant a determination of vesting mining rights for Matcon Corporation's Old Dutch Cleanser Mine. This calcium bentonite clay limestone aggregate and palmicite mine is located on 20 acres with a right to mine under Conditional Use Permit 1, map 113 from 1989, within a 280-acre private property area within the boundaries of the state of California's Red Rock Canyon State Park, which was established in 1968. The mine has existed since 1923 with 11 owners and various levels of activity. Matcon Corporation currently owns the entire 280 acres. For those of you who are not familiar, this is a state park that was established. It's off of Highway 14 across from Cantil, where we have all the solar projects. It is on the way to Ridgecrest. The ability to request vesting mining rights is codified in the Surface Mining and Reclamation Act of 1975, which we abbreviate to SMARA, and further clarified by a 1996 California Supreme Court decision. In 1977, the Board of Supervisors adopted our Smara requirements, and those are in the zoning ordinance. And we have provided those to your board. In order for this vesting right to be honored, mining activity must have occurred continuously along with an intent to mine before the 1976-1977 timeline when Smara was enacted by the state. And then from 1976 to 1989, when they did get a conditional use permit, permits for mining need to be obtained. So as a reminder, what does it mean to get a permit for a mine? That is a conditional use permit. It's a mining permit or a vested mining right. It's an approved reclamation plan for how the site will be reclaimed once operations are finished, and a financial assurance, money or a bond or a letter of credit to ensure that reclamation occurs. That is what we call a mining permit. Vesting rights is a legal term that, when applied to a mining operation that meets the criteria, specifies that the identified site would be classified as a legal nonconforming use. Existing limited mining operations would have to be authorized to expand in accordance with review under CEQA for those areas deemed vested but not yet entitled. So in other words, he has 20 acres under a conditional use permit that he can mine with conditions that he has. But even under a vesting determination, to expand into the rest of the property, it is our legal position based on county council's recommendations that he would still have to go through the California Environmental Quality Act, and he would still have to have a reclamation plan. You will hear from the applicant that he has a different opinion of that, but we are relying on our counsel. Appropriate conditions and mitigation, including financial assurances, would be applied, but complete denial of the right to mine would not be legally available. What vesting provides is this assurance, bolstered by the Supreme Court decision, that you still have to have conditions and you still have to have mitigation, but a local agency cannot say no to it. But it is based on a premise that it has continuously been mined prior to when the rules came into effect, which is 1977. The applicant maintains the fact that it has been a mine, even if not worked, since 1923 makes it a vested right. You have a very big record in front of you, and so I am condensing down this, and we are certainly open to any questions you may have as we proceed. But County Council has provided extensive direction and review and supports staff determination that the lack of evidence from the applicant, all the evidence for vesting must come from the applicant. The burden is on the applicant to prove that it's vesting, not for the county to prove that it's not. All of that evidence does not show any mining activity from 1947 until 1976, which is when the Smara rules came, precludes your board finding the entire 208 acres of potential minerals has a vested right to mining. A full description of the staff analysis and review of the applicant's information has been provided for the record. The Planning Commission heard this case on June 9th, 2022 and denied the request. The applicant appealed that decision. A notice of this public hearing was circulated. To date, staff has received 3,785 comments in support of the staff recommendation for denial of the vesting rights, along with the petition with 3,789 individual comments. Letters have been received from the Center on Biological Diversity, California Native Plant Society, the Sierra Club, the East Kern Conservation District, the Red Rock Canyon Interpretive Association, and the State of California Department of Parks and Recreation, who manage Red Rock Canyon State Park, asking your board to not determine that the applicant has vesting rights on the remainder of the 280 acres. All these comments have been provided to your board. In summary, if it is determined that the property owner, and in this case there have been, as I noted, 11 owners since 1923, if it is determined that the property owner was not using their land for the purposes of mining, then a vested mining right that may have been created was not preserved and cannot be transferred to the successor owner. We do not deny that Old Dutch Cleanser was being mined and sold starting in 1923, but the records show that they ceased mining in 1947. Then the applicant came forward in 1989, did receive a conditional use permit, and did do some mining. There has been no mining on the site since 2008. The denial of vesting rights for the Old Dutch Cleanser mine is appropriate given the inactivity of the site from 1947 until 1976, when the provisions of Smara were enacted, and without further information substantiating the activities that occurred on site Between those dates, when the then current landowner first acquired the property, and from 2008 until the present day, staff remains unable to reasonably conclude that any evidence exists which affirms mining activity commenced or pursued pursuant to any permit or authorizations. The staff recommendation is to adopt a resolution to deny the appeal, deny the request for determination of vested mining rights status. If desired by the applicant, direct staff to continue the compliance review of all the adopted conditions of approval of Conditional Use Permit 1, map number 113, prior to the commencement of any mining activity on site. No mining could occur until any remaining required financial assurances have been provided by the project applicant, and we're prepared to answer any questions that you may have. Thank you.
Thank you, Ms. Oviatt. I'll ask now if there's any questions from the board of staff before I open it up for public comment. Hear from the applicant? Okay, very good. Then we'll open it up for public comment. If there's anyone present that would like to make comments on this item, please come forward, state your name. And we'll ask the clerk to set the clock for 2 minutes, please.
Good afternoon.
No, I'm sorry, never mind. No clock, excuse me. Still on public comment mode.
I'm sorry.
Please proceed.
Good afternoon. My name is Joe Mathewson. I'm the president of Matcon Corporation and owner of the Old Dutch Cleanser Mine, which, as was described, is a 280-acre privately owned parcel, 16 miles south of Ridgecrest, 34 miles north of Mojave, and centered in the northern part of the Red Rock Canyon State Park. As background, I'm a civil and petroleum and mining engineer. My wife and I have owned this property since 1983. We've been paying taxes to Kern County and mining fees to the state for over 35 years, and I've been active in mining in the high desert for over 40 years. Kern County is my second home. I spent these many years in the desert developing mine properties and providing low-cost mineral products for this county and LA County. Your granting of my Old Dutch Cleanser vested status is hereby being requested to preserve a valuable mineral resource that remains an asset here in Kern County and the local economy, bringing in good jobs and whose products benefit the environment. The following presentation will outline our purpose here today is to request your consideration for a vested status, with which we totally disagree with county's findings on a number of fronts. Next slide, please. This is the location of the mine. Next slide. The Old Dutch Cleanser Mine is really part of Kern County's history. It's one of only 2 deposits like it in the United States. It's a 3-product mine. It produces seismotite, calcium bentonite, and limestone aggregate, all critical mineral products for industry in Kern County and in LA County and in the surrounding areas. Next slide, please. Here's some photos of the Old Dutch Cleanser Mine and how it was operated back in the early days, and has since been shifted to an above-ground operation. Next slide, please. This is what the pit looks like today. There are 2 pits. One's a pumice pit, the other's a bentonite clay pit. Both products are open pit mined. Next slide, please. Originally, back in 1923, it was mined by hand digging, underground methods. It's now being mined by mechanical methods. This material was shipped from the mine down to Saltdale, where it was loaded on railroad cars and shipped to Chicago and produced the Old Dutch Cleanser scouring powder that some of you may be old enough to remember. Next slide, please. Likewise, our calcium bentonite clay is a valuable product that has been used in the county. In fact, we closed the Delano landfill with this product, creating a cap and a liner at that landfill with this material. Next slide, please. We're here to talk about vesting eligibility. Next slide. What is vesting? Ms. Oviatt has explained what vesting is, but she has missed a few things that are not quite accurate. Legally, a vested mine is a non-conforming use of the land. Vesting is a mineral rights, is a vested rights is a property right of me, the owner, to utilize my land in a way that was originally intended. Vested right doesn't eliminate the need to reclaim lands or to avoid compliance with other laws, but vesting protects me as a landowner and my property rights. Next slide, please. What is a non-conforming use? Well, you're probably aware that use for non-conforming existed before the restricting ordinance was enacted. In this case, the use started in 1923 and was carried all the way up through 1977, by the Purex Corporation, who was the last mine operator of that property. It was a lawful activity when it began. It was substantial in nature, as you can tell by the pictures, and that the property owners along the line all had an intent to mine, and it really has served no other use. So it's always been a mine, will always be a mine, because that's the only thing it's suited for. Next slide, please. What are they? According to the regulations, California regulations, no person who has obtained a vested right to conduct a mining operation prior to September 72 shall be required to secure a mining approval for such a mining operation as long as the vested right continues and no substantial changes are made. That's the case. That's our case. Further on, it goes on to say that a person will be deemed to have vested rights if prior to 1972, he or she, in this case the owners at the time, in good faith, began mining based on the authorization they had at the time, which there was no requirements at the time, and commenced active mining and incurred substantial expenses and performed work and material. That's an ordinance. Next slide, please. Vested rights defined. It's not ownership that defines the use of the land. It's the use itself. The non-conforming right continues with use. Transfer of title doesn't change it because it runs with the land. Next slide, please. Who makes that determination? Well, the law changed. It used to be the Office of Mines and Geology in Sacramento. That's been recently changed in the last few years to the county. So you are the lead agency in this case, and so you make this decision. And we're relying on you to do so. Next slide, please. Why did we get a conditional use permit? Well, back in 1986, we were unaware that vesting even existed, and so we relied on the county to instruct us as to what was needed. They told us that we needed to apply for the permit, which we did, and we received that permit after 3 years of hard, expensive work of getting it to comply with county regulations, and we received it in 1989, and in 2011, the county told us our permit was in fact abandoned, which it was not. It was only through our vesting application through the Planning Commission did we even find out that our permit was still valid, it was still active, and had no expiration date. After 10 years of trying to work out something with the county staff to put the mine back into operation, this was only recently found out. So we have incurred 10 years worth of not being able to operate as a result of this lack of information or misinformation. Next slide, please. The steps to gaining vesting that we went through. First of all, Ms. Oviatt, it was her idea at a meeting that we had that we should examine the vesting process to be able to examine to see if it was a way around the stalemate we were in on getting a permit reinstated. And so we followed that process. We applied to the county for a vesting status. The county turned us down. We followed that with a request to go to the Planning Commission, which we did. The first meeting at the Planning Commission was tied 2-2, and then they asked us to go back to do some more research and to give them more information on other vested mine actions that were done in other counties, and also to give them some legal findings and precedents, which we did in the subsequent hearing, and you have in front of you. Presumably, you all have this document in front of you. That being said, that outlines these precedents and legal actions taken in other counties by other mining operations. One of which, in Northern California, resulted in a serious filing against the county and an award to the mine owner of close to $1.5 million. $10.5 million, which was later reduced to $1.5 million in settlement fees for that incorrect vesting the court found. So our next opportunity to determine vesting was to come before you and request a vested status of our property rights. And if these actions fail, the next step in this process is to file legal action with the court and seek a determination. And at that time, we will probably seek legal fees and damages from the county for the 10 years we've been delayed in being able to put the mine back into operation. Next slide, please. Burden of proof and procedure. The burden of proof for the landowner is a preponderance of the evidence. That's 50%. The county standard is to provide clear and convincing evidence that the landowner has knowingly and intentionally waived his vested rights. We have not, never have. None of the owners had. Cessation of active mining operations did not indicate abandonment. So the fact that there may or may not have been mining from 1947 or 1958 or even 1980 or 1977 does not indicate that that was abandoned. Those rights were abandoned. Next slide, please. Legal precedents, you've got a whole list of them there and that I've handed out as a supplemental information for you. But the two main ones are Hanson Brothers and Seaman and Hodry, but Hanson Brothers really is the guiding lawsuit. And where it stated, the court stated and found that mere cessation of use does not itself amount to abandonment. Next slide, please. Preponderance of the evidence. We have had, let's see, I can't read that now. The property was solely owned by mineral producers with every intent to continue mine operations based on market conditions. We have proven reserves of valuable minerals that are needed and a benefit to society. The on-again, off-again market conditions demand how the mine is to be operated, and that was one of the primary reasons why it slowed down from 47 to 58 was lack of demand at that time for the product. That has since changed, but nonetheless, the mine is still operating with this under the same conditions that it did back in 47. Reclamation plan and financial assurances are still in place, and mine inspections have continued uninterrupted by Kern County. We've paid all of our taxes, our fees, and complied with annual inspections. The mine has been idle for the past 10 years because of county misdirection, not applicant action. Again, the county must prove the intent to abandon in a clear and convincing manner, and they really can't do that. Next slide, please. Our landowner evidence. We have evidence. It was prepared for us actually was given to us in a letter back from Purex Corporation when we acquired the mine that frankly said that they have been operating the mine over the years with every intention to continue mining. That is written proof from the landowner from which we acquired the mine. The county has no such documents that disprove that. And have no other evidence to show that there was no mining done during that period of time. During this also, while we have had the mine, we have paid over $215,000 in property taxes to the county and around $55,700 in compliance fees. Next slide, please. What constitutes relative evidence is basically two things. One, a written or oral evidentiary statement, and evidence of mining activity commenced before 1972. Those two are clear. Mining did occur before 1972, and I have given you oral and evidentiary statements in the previous slides. Next slide, please. There's 7 reasons why we feel we qualify for vesting. One, it's only been a mine since operating in 1923. It is and always will be a mining property because it really is suited for no other use. All the mine owners since 1923 have a stated intent to mine the unique mineral resources that are present on this property. It's one of only 2 deposits in the United States that have this high quality material. And all of these 3 products are highly desired and needed in the industry in both Kern County, LA County, and the surrounding areas. Next slide, please. The mine holds in perpetuity the legal rights to the same access road that has existed since 1923. And while originally unnecessary, totally unnecessary when we started, the mine was fully Smara permitted. We went through the permitting process in '89. It took us 3 years to get that. And the conditional use permit has not expired and has not been abandoned. Though not required, if we're successful in investing, Matcon intends to continue to voluntarily comply with the intent and conditions of the approval of this original permit and continue working with the county to be in compliance. That won't change. Next slide, please. The current staff conclusion is incorrect. The property has never been used for anything other than mining. It's only been deemed abandoned due to the problems we've had with the permit with the county, the stalemate we've had with the county over the last 10 years. There's currently an $81,000 financial assurance instrument in place. And there is no ability for this county or anyone else to factually disprove whether mining was done between 47 and 86. And we have a letter that shows from Purex that says it was done. But we don't. But legally, we don't have to prove it. The county must disprove it with facts, and they don't have those facts. Next slide, please. The Old Dutch Cleanser mine has been the subject of 2 separate biological and cultural assessments during which previous permitting was done. And the county had, when they told us our mine was abandoned, they told us we had to apply for a second Smara permit, which we did. We went through it again. Took it all the way up through the public hearing, and because of comments received, they decided that no, they didn't want to take it to public hearing, and that's where we've been in the stalemate for the last 10 years, because they at that time wanted us to sign up for a $250,000 environmental impact statement to restudy the studies we've already done 2 other times, and to which we objected. We have a permanent easement. We've always actively mined and intended to mine the deposits, and we basically have been prevented from mining over the last 10 years because of our stalemate with the county. Next slide, please. Again, the claimant, which is us, has only to prove by preponderance of the evidence demonstrated through testimony and exhibits with just enough evidence to support the claim we have for vested rights. Whereas, and that's considered as just enough evidence to make it more than likely that what we're asking for proves is true. Whereas the county has the overwhelming burden to provide clear and convincing evidence and distinct proof that there is no basis for vested rights claim. They have not met that burden. Next slide, please. We feel we've clearly met the burden of proof and are simply asking your board for an affirmative vesting determination for our Old Dutch Cleanser mine. This basically recognizes our property right for us to be able to develop the entire deposit in compliance with the existing conditional use permit, even though that permit was unnecessary. We're not changing anything. We're asking to stay. All we're asking for is the ability to develop the whole deposit, expand outside the 20 acres without having to go through an entire new permitting process. That's what vesting will give us. Next slide, please. You're the ones with the rightful authority to make this determination. Your approval, therefore, is respectfully requested, and we hope that you will give us every consideration of this request. Next slide. Do you have any questions of me?
Supervisors, are there any questions at this point?
Not at the moment.
Okay, not at the moment, sir. Thank you. Thank you for your presentation.
Thank you for your time.
I'll now ask if there's any other members of the audience who would like to make any comments on this item. Okay, seeing none, I'll first return to staff and ask Ms. Oviatt, do you have any further information you'd like to provide or any comments on anything that we just heard?
I do. Chairman Scribner, members of the board, I believe that given the record that we have, I need to provide more information on what the facts, as MatCon Corporation sees them, are inaccurate. So number one, the Bureau of Land Management, which is federal land and has the access, did give him a right-of-way. They have indicated to us that it is not a permanent access, and it is one of the requirements of his conditional use permit. Second, if Mr. Murphy could put it on the overhead. The reason that he was required to come forward for a permit is mining was done in 2008 outside the 20 acres that he was authorized to do. So if Mr. Murphy can explain where the 20 acres of the conditional use permit approval is, and then show us where the mining happened, which is the red for those who can see the red. So that is the reason that he was found in violation, and he was told that he needed to do a proposed CUP 8 instead of CUP 1. When it did go to the Planning Commission, we did do a mitigated neg deck. Your board is very familiar with the California Environmental Quality Act. A mitigated neg deck says that you can reduce all impacts to less than significant. This is in the middle of the Red Rock Canyon State Park. There are aesthetic impacts, there are biological impacts. Many of the comment letters you've received today extensively show those. When it went to the Planning Commission, we received the same types of letters, and we indicated that it needed to be referred back, that a mitigated neg deck was not sufficient. We have not held up this project. The applicant has declined to do the necessary California Environmental Quality Act process that unfortunately in California is the law. So that is where we are at. The conditional use permit for 20 acres of mining is valid. There are 46 conditions. He has complied with almost all of them. We've been meeting with him regularly to review them. And there is no other hearings or other things required for him to mine the 20 acres. This vesting is to apply to the rest. Again, the representation that vesting allows you to ignore the California Environmental Quality Act and not have to go through a permit reclamation process is inaccurate. We have given vesting rights to Cal Portland, and their lawyer, one of the best mining lawyers in California, clearly states that CEQA applies. We have also given it to the Sand Canyon mine. The Supreme Court now requires that we have a public hearing, so we're having a public hearing on vesting rights. The dispute with this particular applicant goes beyond the vesting rights to the belief that vesting rights will somehow relieve this mine of all modern requirements. That is just simply not accurate. Once again, I would like to put officially into the record, if you go online and you Google Old Dutch Cleanser Mine, there are geological reports, at least 6 of them, that say that the mine was closed in 1947. These range from historical geological reports to reports at the state of California that say the mine was closed in 1947. What happened between 1947 and 1977, there's no evidence of except for this one typed comment from an owner who was attempting to sell the mine. Lastly, we certainly are a supporter of mining. The representation that somehow Kern County doesn't support mining, we have 2 of the largest aggregate mines from granite, Vulcan. We have US Borax, the largest borite mine in the United States. We have 100 other mines that we manage. You simply must go through the process. And we certainly want to continue to say that on the remaining 280 mining 20, on the remaining process, we are certainly prepared to move forward with a conditional use permit on the remaining mining with an appropriate CEQA document, which in this case is an environmental impact report. That completes my comments on the record. There are certainly could be other comments that County Council wants to add into the record, but this is a legal determination. This is not a discretionary action, and we have relied on Council's direction and the Supreme Court decision, which we believe gives us the conclusion that this is not a vested mine. Thank you.
Thank you, Ms. Oviatt. I'll now return to the board.
Do I have the opportunity to rebut that?
I'm going to turn to the board, and if a board member would like to provide you an opportunity to answer any questions, then I'm going to allow them to. So I'm going to go to Supervisor Peters. This is in his district.
Thank you, Supervisor Scrivener. Just out of curiosity, why did Metcon originally apply for a CUP in 1986, like it was showing in this document?
We had no idea that the vesting rights even existed, that it was even an option to us. We were naive at the time, I guess, when we bought the mine, and we went to the county to see what it was going to take. Nothing was needed prior to that. It had been actively mined, but they told us at that point in time, because of Smara, we had to apply for the permit, which we did.
Okay, so because of Smara?
Correct.
Okay. And just out of curiosity, this is for our staff. If, let's say the vesting rights aren't approved today, does that prevent the applicant from, at some point in the future, after going through the CEQA process and any of the other required state processes and getting whatever compliance is done and then applying for that at a later date?
Supervisor Peters through the chair, that's correct. If they're denied today and he has other evidence that he wants to bring forward, he can always come back and reapply. There's no time limit there's no number of times that you can apply if you have other evidence that you want to put in the record.
Understood. So I was looking on Google, as you mentioned earlier, and it's listed on Google as the abandoned Old Dutch cleanser mine. If you pull it up just on Google Maps, I mean, that's what it's listed as. It shows pictures of graffiti in the mines and people out there in their Jeeps and using it looks like a campground out there. And so, is it? It's been sitting. I'm guessing you said since 2008.
Yes, for the last 10 years, it's been basically sitting unoccupied, not able to mine. And when, as Ms. Oviatt indicated, those references in all those reports, when they say the mine was closed means it's not in operation. It doesn't mean that it was abandoned. Because there was no mining going on, means that it was not closed. The mine was not closed. There was no official closure of it. There's no document that shows that it was closed. It just mining ceased. Because at that time there was no market for the product. And then over the last 10 years, we have been unable to mine, but yet the weekenders and recreationalists use it as it's even a video on YouTube about their tours of the mine. We've been unable to keep those folks out of the area. Have had a gate up numerous times, and they have been broken through or gone around. And so during the last 10 years, we've been able to, we have basically been unable to do much with the mine other than trying to get the resolution on the permit.
Okay. And did you say at one point that there was a letter from a company? I made a
Yes,
note
sir.
here. I think I misunderstood you. Was it Purex maybe
That's correct.
that they had a letter that there had been continual mining on this property?
That is correct, and it's one of your slides is in there. It's an excerpt in one of the slides that states that it was from the Vice President of Purex to us when we purchased the mine, where they clearly said that they had been mining for many years, and it specifically dealt with the access, and which is another issue that I have a problem with what was purported.
This was the letter from 1983
Yes.
or
Well,
82.
It's shown that from it says on the top, landowner evidence, where it says 1947, 1983, owned by Purex Corporation. Their statement was dated 1982. That was an excerpt from their letter,
Okay.
and the county has a copy of that.
Understood.
But the other issue that was raised was I'm sorry, I lost that one.
No.
The other part of your question.
No problem. I think that answered it for me. And my only other question, I don't know if we have an answer to this right away, but as far as, I know there was some type of bond or some assurance for reclamation at some point. How does that process work? Does a mine have to sit for X number of years before that would have to take effect? Because if you could just say, we plan to continue mining at some point in the future, I imagine everybody would do that.
Supervisor Peters to the chair, that is an issue. We do have financial assurances on record for mines, and you are supposed to either start mining again or reclaim. And we, of course, based on a business-friendly atmosphere, tend to allow those to go on for quite a while. I want to point out that he has a conditional use permit. He was mining outside of his area. He could have said, I'll reclaim the areas that I mined outside and I'll go back to mining. We did not hold him up from mining. It was his choice on how he approached a solution to this violation.
Understood.
But yes, we are not we do not immediately, if you stop mining, we do not immediately say, well, you need to reclaim.
Right.
We do give people time because of the market for certain minerals that goes up and down. And so there may be a time.
Understood. Thank you.
But to further answer your question, that there's a amount of $81,000 that's on file with the county for reclamation of that, for that acreage that's been disturbed. Every year, the county inspects it and goes out and takes a look at it, and we have to do a cost estimate for closure against that amount. And if the cost estimate is more than that, we have to deposit more money with the county in order to cover that estimated cost of closure.
And that's on the area where you currently have the CUP?
That's correct.
Okay. Does county council have anything that they want to add or feel that needs to be included at this point?
Supervisor Peters, through the chair, I'm going to have Deputy Phil Hall address that.
Thank you.
Supervisor, through the chair. My mic on? Supervisor, through the chair. I think I should add two things here. We've talked about, we've heard about abandonment today. Abandonment isn't really the issue here. It's whether or not the mine was dormant in 1976. The case actually says, Smara's grandfather provision, this is a quote from the Hardesty case, Smara's grandfather provision does not extend to truly dormant mines. That means in 1976, on January 1st, was this mine dormant. As we've heard, market conditions, people might be mining one day, they might spend some time not mining, but on 76, was it actively mining or sort of in a suspended state because of the market is what you need, what you're looking at, not whether or not it was abandoned completely. And by the way, the Hardesty case is very similar to the case we have in front of us. That was a gold mine, but it stopped mining during World War II, and somebody reactivated and started mining again in the 90s. So it's very close in this, on the facts. The other thing is we should understand here is the burden of proof is not on the county at all. This is the applicant's request for vesting, and the case law is really clear. The burden of proof is on the party asserting a right to a non-conforming use, that's asking for the vesting, to establish lawful and continuing existence of the use at the time of the enactment of SMARA. And that's the parameters we're working under.
Understood, thanks. No further questions for me.
Thank you, Supervisor. Any other questions or comments by members of the board? Supervisor Couch.
Can you explain the last comment you just made in terms that the average person can understand?
Sure. The applicant is requesting this board make a finding for them. They're requesting that you make a finding that vesting has occurred, that he has a right, that he wasn't dormant in January 1st, 1976, and the burden is on him to show that he was not dormant in 1976. Not abandoned, but dormant.
And is there a legal definition of the term dormant?
There is not a legal, you would just go to your standard Webster dictionary for this one.
Can I add one more comment? Again,
Please
I want
proceed.
to reiterate the purpose of what we're asking for is not, we intend to comply with all our conditional use permit that's currently in effect. All conditions will be met. The concern that we have is that in order to expand the mine and develop the resources that are there, to have to go through a completely new SMARA permitting process that will take years and not allow the mine to be developed the way it should be. That is our concern, and that's why I'm asking for the vesting consideration, because that will, contrary to what Council or Mr. Murphy has said, we're not trying to get out of anything. We're merely trying to protect our rights as a landowner and mine owner to be able to expand and develop the entire deposit in accordance with conditional use permit, without having to go back through and redo everything that's been done twice now, and incur more studies that we've already gone through twice, and incur that cost and that time. Secondly, the other inference was made that our access is not permanent. That's not correct. That is in perpetuity. It's a contract we have with BLM that we renew every 30 years by paying the fees every 10 years. We can keep that access for as long as we want to, or as long as it's needed. So those two things are different. But again, my whole purpose of this presentation to you is to protect our rights as a landowner to develop our mine fully and exploit the resources that are there that are valuable without having to go back through an entirely new permitting process. Thank you.
Thank you. Supervisor Maggard?
Thank you, Mr. Chairman. Could staff, whether legal or planning, help me? I'm trying to weigh the pluses and minuses of this. So could you first tell me what is the benefit to the people of Kern County if we go with staff's recommendation? And then secondly, tell me what is the detriment to the people of Kern County if we go with Mr. Mathewson's assertion?
Supervisor Maggard, through the chair. First, I'd like to address Mr. Matheson's representation is not correct. This is based on legal counsel's advice. Vesting rights does not mean that you get to take the 46 conditions for the conditional use permit, which has a boundary of 20 acres, and apply it to the rest of the property. That is not what vesting rights gives you. That is not true. You would still have to do a reclamation plan, which requires a public hearing, and you would still have to go through the California Environmental Quality Act. Once again, this is not just our counsel who says this. This is mining lawyers that have brought their vesting rights to us, and they have made the same representation. What does vesting? So this means that 280 acres, if you give him this vesting, means that 280 acres could be mined in this area after you go through a public hearing. However, you could not say no to it. That's all the vesting means. The vesting means you can't say no to it. And if someone wanted to sue us over it, we would be defending in court the right that we can condition it, we can do it, and we would be sued by the state of California and by the other people who concerned about Red Rock Canyon State Park. And legitimately, he would have to pay all those costs. We would be defending, here are the conditions we're going to put on this, but it will fundamentally change how you experience the park because of its location. It is in the middle of the park, right? So that's the first advantage to us. Number two, it does not meet the qualifications. This is a bright line law issue. If we give this and it doesn't meet the qualifications, I have 100 other mines that have been mined but haven't actually operated for hundreds of years that are going to show up and say, well, I should have the right to mine too. So for us, it's about the precedence as well. There's either a clear definition of what a vesting right is and what kind of evidence the applicant has to bring forward legally. It's not a discretion like if we want the mine. The advantage to him is, once again, this mine is in a difficult location. It's inside a scenic state park. The park has reached out to him to buy this a number of times. My understanding from the park, from the state of California, is the problem are these underground tunnels. These are underground tunnels that people wander around in. As he indicated, he has not been able to actually, it's hard to control them because the gates are in pumice, and so you just pull the gates out. The state of California says that they would have to take explosives and collapse all of these in order that it would not be a liability. And their counsel said that's probably not a good idea. They are now continuing to try to figure out how to acquire this property because people want this to be part of the park. So the advantage to him is that at that point, even though he has to still go through this process, still pay for the environmental impact report, at the end of the day, you can't say no to it.
Just to shed some other light on this, we're currently in negotiations with State Park and California Fish and Wildlife to donate 150 acres of that 250 to Red Rock Canyon State Park and pay them to take it, which is because it's mitigation land. And so that issue is somewhat mitigated, but nonetheless, the hundreds of letters that these folks got have no clue about that, that they sent in. But we are cooperating with state parks and have been all along. But our intent is to develop the 100 or so acres that is mineable, not the whole 280, and the 150 that we're going to donate to the park is to benefit the park. So that issue is still fluid, but we're in the process of finalizing that.
Thank you. Supervisor Maggard, do you have any other questions or comments? Okay, very good. Supervisor Peters?
Thank you, Chairman. After hearing all this, it's a difficult situation. I get that. My background is in the oil industry. I get dealing with the state of California on environmental issues. It's maddening at times. This board definitely understands that. But in hearing everything that I've heard, I know our planning department is working diligently to try and get as much business as we can here. And I trust our council's legal expertise on this. So I'm going to make a motion on staff's recommendation.
Thank you, Supervisor. Do we have a second?
Second.
A motion and a second. Any other discussion from the board? Seeing none, you have a motion and a second. Please cast your votes.
The motion is approved. All ayes.
Thank you, Mr. Mathewson. Ms. Obiot, thank you for your testimony. We're going to move on to the next item. Next item is item number 4, also under Planning and Natural Resources Department. Request of Ravjir Gill, and the original applicant on this project is Jagdeep Ranji, to appeal the decision of the Planning Commission to allow the original applicant to continue operation of an illegal agricultural trucking facility without benefit of building permits or land use approval on a 2-acre site located on South Union Avenue, approximately 500 feet north of East McKee Road in the Bakersfield area. And this one is in District 2. So Ms. Obiot, can you start us off on this discussion, please?
Thank you. I'm going to have Craig Murphy, Assistant Director, present this case. Thank you.
Good afternoon, Mr. Chairman, members of the board. So the project before your board today is an appeal to violation map number 12432. That was a decision of the Planning Commission to allow the original applicant, Mr. Jagdeep Rangi, to continue operations of an illegal agricultural trucking facility without the benefit of building permits or land use approval, all in accordance with the Kern County zoning ordinance. So the project applicant for this request, this is the appeal, is from Mr. Ravjir Gill. The purpose of today's hearing is not to consider whether or not to approve the required conditional use permit proposal, but rather to determine, 1, if a land use violation does in fact exist on site, and then 2, if it is determined that a violation has occurred, whether or not the existing operations may remain on site while staff processes the required land use applications. The land use violation was originally considered by the hearing officer on April 21st, 2022. The hearing officer concluded that a violation did in fact exist, and the decision of the hearing officer requiring the project site cease all operations was appealed to the Planning Commission by the original applicant, Mr. Rangi. This decision to cease all operations on site was primarily due to the fact that there was no known permitted water connections to service the site at that time. On July 14th, 2022, the Planning Commission considered the appeal. The Planning Commission determined that a violation did also exist on site. However, the Planning Commission made appropriate findings and stipulations authorizing the trucking facility to continue operating while that conditional use permit was being processed. That decision by the Planning Commission was appealed by Mr. Gill, and that is the item that has been brought forward for your board's consideration today. So the project site is a 2-acre parcel that has a map code designation of low-medium density. The site is zoned agricultural. However, a low-density residential zoning classification is in suspense that would become effective upon the recordation of any final subdivision map. Access to the site is provided off South Union Avenue, and the adjacent residential neighborhood has been annexed into the city of Bakersfield. The site currently contains the trucking facility, which operations include a use of 24 semi-trucks and trailers, a large unpermitted pole barn used for conducting truck repairs, an unpermitted carport structure. Site includes 3 unpermitted cargo containers, one of which may have been converted into an office. And then at the time of inspection, the site also contained porta potties, pieces of equipment, a welder, metal scraps, and various tires. So here are some photos of what the site looked like in April and July of this past year. So since that time that the original investigation was done by code compliance and planning staff, the trucking operator has cleaned up the project site by removing all the miscellaneous equipment, trucking parts, and scrap metal. Additionally, the operator has disconnected any of the unpermitted water or electrical infrastructure, and they've stopped utilizing all of the unpermitted structures, which include that pole barn, the carports, and the various cargo containers. And what I'd like to do now is show you a couple pictures of what the site looks like currently. So ultimately, it is the desire of the original project applicant, Mr. Rangi, to be allowed the continued operation of the site with a maximum of 24 trucks while the conditional use permit is being processed. The proposed hours of operation would be from 6 a.m. to 8 p.m., Monday through Saturday. According to our Kern County zoning ordinance, an operation that is in violation is allowed to continue those operations provided that the following 5 findings can be met at a designated hearing. The findings include, first, that the violation or the violations will not likely result in potentially significant health, safety, or welfare impacts on the property or the surrounding properties. The second, the property owner has provided written acknowledgement of the existence of all violations of the title affecting the property by which that permit is being sought. Third, the property owner is presently not known to be in violation of this title related to any other property owned over which the county has land use authority, unless that property's violations are being abated with the current application before the hearing officer. 4, the application, if approved, would fully abate all violations of the title affecting the property for which the permit approval is being sought. And 5, all outstanding administrative penalty fees, administrative costs, civil penalties, and enforcement costs that have been incurred by the department of the county in investigating and seeking to abate the violations of this title affecting that property and known by the hearing officer have all been paid. So based on the existing operations and statements from the original project applicant, there is no doubt or question that a violation does exist. Any operation of an ag trucking facility at this location would require land use authorization through the issuance of a conditional use permit. So the options before your board today include, 1, to conclude that a violation does exist on site and make appropriate findings, authorizing the continued use of the project site in accordance with the recommended stipulations during the process in which the CUP is being done. Or your board can conclude that a violation does exist on site and then make the appropriate findings that continued operation of this ag trucking facility in the interim of processing that CUP would result in significant impacts, and you can require the project proponent to cease all operations and remove all materials prior to staff ever moving forward with processing that conditional use permit. So in conclusion, the site has been operating as an ag trucking facility for about 10 years now at this location without any known incident or long-standing complaints from the adjacent residential property owners or residents. Upon our initial investigation of the land use violation in 2021, the project proponent has demonstrated through tangible actions appropriate steps to address that violation. Those includes the submittal of a conditional use permit application, the retention of a consultant to assist the processing of that application, removal of all the miscellaneous trucking equipment, parts, and scrap metal on site. The applicant has disconnected any of the unpermitted water or electrical connections, and they've provided written agreement to reduce the existing services to a minimum standard necessary that would allow for the continued operation of the facility, which includes not using any of the structures that have not received any building permits. So based on a review of the record, staff is recommending that Mr. Rangi be allowed to continue operation of the site, provided he can meet the 10 stipulations that have been found on pages 8 and 9 of your board staff report. Adherence to those stipulations are necessary to help ensure that the violation will not likely result in any potentially significant health, safety, or welfare impacts on the property or the surrounding properties. What I'd like to do real quickly is just run through what those conditions are. So the first condition, within 30 days, the project proponent needs to give staff written acknowledgement that only a maximum of 24 trucks would be utilizing the site at any given time. They would provide acknowledgement that no portable generators or electrical power will be utilized without any of the appropriate permits. They will provide, the project proponent will not repair any trucks or conduct any maintenance operations that are not within their own fleet that they maintain. The project proponent shall not perform any vehicle maintenance or repair to their existing fleet under the unpermitted pole-borne structure during the processing of the CUP. Further, other than minor maintenance, which can occur on site, any major vehicle repairs such as engine overhauls, oil changes, need to be performed off-site. If the proponent is not sure whether or not an activity constitutes a major repair, they will contact staff for written clarification prior to performing any of those questions activities. Staff believes that stipulation is necessary as we have no known water connection. And so if you're doing too much work on a vehicle and something were to happen, we don't have water at the site to address that concern immediately. Additionally, cargo containers, we're recommending that they be allowed to remain on site. However, again, they have not received building permits, and as such, any of that use is limited to only the property owner. Condition 2, within 30 days of the effective date of decision, the project proponent needs to provide all our necessary applications to move forward with our conditional use permit. Within 30 days of the date, the project proponent has to pay the outstanding administrative penalty fees. Within 30 days of the decision, we are also indicating that the project proponent needs to provide written authorization, allowing any representative of the Code Compliance Division the authority to go on site Monday through Friday between 8 and 5, just to verify that the recommended stipulations are being adhered to. Within 30 days, we are asking the project proponent provide any photographic evidence that the existing unpermitted cargo containers, the unpermitted pole-borne structure, are not being utilized for repairs, and that all the parking has been appropriately roped off for purposes of access and will not be utilized during the processing. This requirement needs to continue until the time those building permits have been issued for those structures. Again, because they have not been inspected by our staff, the concern is that they could fall over, and so the stipulation indicates they can remain on site, they just can't be utilized during the processing of the CUP. Again, for those items, if additional time is needed to provide that evidence, Condition 6 or Stipulation 6 allows the project proponent to provide a written request for the planning director asking for additional time for whatever reason that they were able to adhere to those 30-day time frame. Stipulation 7, because the site is completely dirt, the project proponent needs to be responsible for implementing any appropriate actions necessary to help ensure that dust on site does not occur to the adjacent residential parcels. And then Stipulation 8, if during the course of Stipulation 8, if during the course of processing this application, for whatever reason, the Public Works Department determines that it's appropriate to have a right turn in and a right turn out only access off of South Union, the Public Works Department would provide that written statement to the project applicant, and then that applicant would be responsible for making sure that his trucks utilize that ingress as a right in, right out only. Finally, Stipulation 9 is just a statement that if staff discovers any additional violations, we would have to stop processing the CUP, and then we would have to go back to a violation hearing to make sure those were addressed before we move forward. And again, that is the same in terms of Condition 10. 9 and 10 apply to that general principle and standard. So ultimately, the department recommendation is for your board to adopt a resolution and recommended findings denying the appeal and authorize the continued use of the project site as an ag trucking facility per the recommended stipulations, instruct staff to continue processing the requested discretionary actions, all subject to the stipulations deemed necessary to affirm adherence to the findings pursuant to sections 19.114, 020C and D of the zoning ordinance. That completes staff's presentation. I'd be happy to answer any questions your board has regarding the violation process or any of our recommended stipulations. When you do open this item up for a public hearing, Mr. Gill is the appellant who is appealing the decision of the Planning Commission. So Mr. Gill should be allowed to provide his testimony first, followed then by the original project proponent and the operator of the ag trucking facility, Mr. Rangi.
Thank you, Mr. Murphy. And I'll ask first, are there any questions from members of the board before I go to the public? Okay, seeing none then, we'll ask if Mr. Gill is present and if he would like to make any comments as the appellant. Is Mr. Ravjir Gill here, and would he like to make any comments? Okay. What about our original applicant, Mr. Rangi? Good afternoon.
Good afternoon, board members, county staff. My name is Kristen Piddick with QK, and I represent the original applicant on this project. I would like to thank county staff for working with us throughout this process and providing that presentation today. All of the facts that they detailed were accurate and correct. And I would like to just express how diligently that our client has been working towards obtaining a conditional use permit. As Mr. Murphy stated, at the original director's hearing, Mr. Gill did show, and it was clear that he was opposed to a dispute with the individual outside of the project. His dispute had nothing to do with the project. It had to do with an issue dealing with some church items. So I just wanted to bring that forth today just so that you were aware of that testimony that was given at that time. And that we agree with staff's recommendation to support the denial for this case today. My client is here today and he said that he would like to give a few statements, and we're happy to answer any questions that you have.
Very good. Thank you.
Thank you.
Mr. Rangi, good afternoon.
Good afternoon, everyone. I really don't have much to say except for just one stipulation, stipulation number 4. The yard usually remains locked at all times just because we don't have electricity and water there. So it's kind of tough to kind of provide that into written notice that, hey, you guys can come in anytime at 8 a.m. to 5 p.m. If there's any other way we can work this out, just because the yard is mostly locked. Unless the truck needs to leave in and out to where, some of the drivers have a key to where they can open the gate, lock it once they leave, or I have a key, or, my dad has a key or somewhere in our family business who has a key that can go open the door for the driver and lock it once they leave. So I don't know how to work around that or with that, if the county staff has any recommendations for that.
And you're talking about during because the item 4, it says during normal business hours of 8 a.m. to 5 p.m. And so you have concerns that you would be able to have the yard open if a code compliance officer came during the regular business hours or after hours?
Or regular business hours, because even during regular business hours, the yard is locked. We have equipment there, like tires and stuff like that. That's worth a lot of money. So we usually keep it locked just so it doesn't get stolen. So,
very good. I'll ask Ms. Obiad or Mr. Murphy if they can address that concern.
Sure. Thank you, Mr. Chairman. So the purpose of that condition was just simply that staff needs to help as we continue to go forward, just verify that all the stipulations are being adhered to. I don't think we have any intention of going on the site when Mr. Rangi is not there. I just know that at one time when staff was trying to initially investigate what was going on, it was just difficult to be able to see the site. And so I guess we could modify that stipulation to specify that within 30 days of the effective date of decision, the project proponent shall provide written authorization allowing representatives of the Code Compliance Division an authority to enter the project site during normal hours, Monday through Friday, 8 to 5, for purposes of inspecting the site. If Mr. Rangi provides his contact information and his phone number, those visits can be arranged through contact prior to. Again, it is not our intent to surprise and just show up at any time. We just want to make sure that we're verifying that repairs aren't being done, that they're not using the unpermitted building structures. And so I would just add language at the end of that project proponent shall provide his phone number, and code compliance shall attempt to contact and work out a time to come inspect the site if they need to.
Thank you, Mr. Murphy. Ms. Obiad, did you have any additional comments?
I would just like to say phone number and email.
Yes, ma'am.
That's fine.
Ms. Ring, you're in agreement with that?
Yeah, I agree with that. Thank you.
Very good. Okay.
Thank you, guys.
Thank you. Appreciate it. Any other comments from members of the public on this item? Okay, seeing none. This is in my district, and so I'm as chair, I don't make motions, but I would request a member of the board to make a motion to deny the appeal and to allow the facility to continue to operate as we process the conditional use permit. I believe there's some findings perhaps that need to be read into the record to that effect, but that is my desire at this point.
I'll move that motion.
Mr. Chairman, I think the only revision here is I just want to make sure I turn okay. So basically, adopt a resolution, recommended findings, denying the appeal, authorizing the continued use of the project site as an ag trucking facility per the recommended revised stipulations, which that includes our revision to stipulation 4 as read into the record, and instruct staff to continue processing the requested discretionary actions, all subject to the stipulations deemed necessary to affirm adherence to the recommended findings pursuant to sections 19.114.020C and D of the zoning ordinance.
Thank you, Mr. Murphy. So do we have a motion to that effect in a second? I know I heard some, but.
So moved.
Motion, Supervisor Perez.
Oh, second.
Second, Supervisor Peters. Thank you. Please cast your votes.
The motion is approved. All ayes.
Thank you, and appreciate you being here to provide testimony. So that will take us to the next item on our agenda, and that is located on page 7 of our agenda. This is item number 28. This is under the County Administrative Office, and this is a proposed side letter agreement with Kern Law Enforcement Association providing a $2,000 monthly housing allowance for deputies residing in and assigned to outlying area substations. And so we have Devin Brown here with us, who heads up our Human Resources Division. Good afternoon, Mr. Brown.
Good afternoon, Mr. Chairman, members of the board. This item is coming to you after a few months of preparation at the request of Sheriff Youngblood and his staff. Our county administrative staff, with their assistance, began developing an incentive for deputies who are assigned and living in outlying area substations to incentivize staff to transfer there or develop connections to the communities that they work in. As part of your budget this year, we set aside about $1 million for a potential housing allowance for those deputies who are assigned to work in the outlying areas of Kern County if they also have a primary residence there. The union that we work with for deputy sheriffs is our Kern Law Enforcement Association. We've been working with them over the past month or two to negotiate the terms of this proposed housing allowance, and we're bringing the attached side letter agreement to your board today for approval of that housing allowance. The Kern County Sheriff's Office and the county have an interest in providing this incentive to sworn law enforcement personnel who live in those outlying communities to which they're assigned to reduce and deter crime in those areas and have staff readily available to respond more quickly to emergent calls for service, which I know your board is well aware. You get lots of comments from residents out there about our service time. The proposed allowance is $2,000 monthly for housing, and it's for those designed to assist employees financially with the monthly expenses of living in those response areas, particularly Kern Valley, Mojave, Boron, Ridgecrest, Rosamond, and the Fraser Park substation response areas. We have reached agreement on the proposed terms before you and this continue the side letter agreement with Kern Law Enforcement Association, and County Council has approved it as to form. We are recommending that your board approve the side letter agreement with KLEA and direct us to begin implementing the $2,000 per month housing allowance, which will take effect at the end of this month, at the beginning of the next pay period, and be available for any questions you have.
Thank you, Mr. Brown. Any questions for Mr. Brown from the board before I ask if there's any other testimony from the public? Okay, I don't see any questions. Thank you, Mr. Brown. Do we have any members of the audience that would like to make any comment on this item? Okay, very well. Seeing none, then I'll return to the board.
Motion. Second.
So we have a motion and a second to approve staff's recommendation. Please cast your votes.
The motion is approved. All ayes.
Thank you. I'd like to thank staff and congratulate them on bringing this item to us, which obviously is designed to assist with our retention and recruitment efforts for our law enforcement officers. Very important. Thank you. Item number 29 is Item number 29 is a request to employ retired county employee Paris Whitley, waiving the 180-day waiting period to fill a critically needed position as a fire prevention inspector 1, salary range 60, step 8, in the fire department, effective October 15th, 2022, for the period expiring June 30, 2023, for a maximum of 960 hours in fiscal year 2022-23. Mr. Brown, please.
Thank you. Again, good afternoon, Chairman, members of the board. This item is a legal requirement to hold off consent for the request to employ a retired county employee, Paris Whitley, to fill a critically needed position as a fire prevention inspector 1 with the Kern County Fire Department, effective October 15th, 2022, which is a Saturday. The California Public Employees Pension Reform Act of 2012 requires anyone who is returning as a retired annuitant to sit out 180 days between their retirement and return, unless the employer certifies that the appointment is necessary to fill a critically needed position with specialized knowledge and skills before the 180 days has expired. The appointment must be approved by your governing body, the Board of Supervisors, in a public meeting, which we're here today. Mr. Whitley retired in July of this year, so he hasn't quite sat out 180 days for the date of his retirement, but the department needs to reemploy him to fill this critical role to ensure that services are delivered to the community by the Kern County Fire Department in the fire prevention inspection capacity. KSARA has approved this position for rehire, and we're asking your board today and recommending that you certify that this reemployment is necessary to fill a critical service, and approve the request to employ retired county employee Paris Whitley as a fire prevention inspector 1, ranged 60, step 8, for the period expiring June 30th, 2023, for a maximum of 960 hours in fiscal year 2022-2023. And I'd be happy to answer any questions you have.
Thank you, Mr. Brown. Any questions from the board of Mr. Brown? Okay, seeing none, any members of the audience that have any questions or comments on this item? Okay, seeing none, the requested action is to approve.
Motion to approve.
Second.
You have a motion and a second. Please cast your votes.
The motion is approved. All ayes.
Thank you. That brings us to the conclusion of our business, and our next meeting would be October 18th, 2022. So do I have a motion to adjourn to October 18th, 2020?
So moved.
Wait, sorry, excuse me, Madam Clerk. Oh, I'm sorry, I missed I'm sorry, October 25th at 9 a.m. is our next meeting.
So moved.
Thank you.
May already be